I'll try to keep it as brief as possible and as simple as possible. Sanctions are an instrument to bring about a change in activities or policies, such as violations of international law or human rights. Sanctions may be imposed by the EU on an autonomous basis or by implementing binding resolutions from the Security Council of the UN. They target, and sanctions and restrictive measures are in fact the same. They may target third country governments, non-state entities, individuals, and may comprise arms embargoes, import and export bans, travel bans, financial restrictions, and other measures as appropriate. Basically, sanctions impact all businesses that are involved in a transaction with a sanctioned party or a sanctioned country. Let's take Russia as an example, because that's a hot topic these days. It's a misunderstanding that all transactions involving parties in Russia are prohibited and fall under the scope of the EU sanctions against Russia. Well, what we see in daily practice is that if a transaction is authorized, either because it does not fall under the scope of the EU sanctions against Russia, in my example, or the competent government in the country where the exporter is established has issued a license to authorize the transaction, what we see is that banks refrain from processing payments from a Russian bank account to a European bank account. That all has to do with the banks implementing themselves the restrictive measures against Russia, but in a much more stringent way than is required by law. And just by protecting themselves and complying with the regulation, they refrain from processing such transactions. And that is for exporters really a burden and a major issue, where they have supplied legally products or services to Russian customers, but where they encounter issues when receiving the payments. What clients can do if their business is impacted by sanctions is minimize disruption. And it all comes down to compliance. What you need to do is to make sure that upfront you have performed clear due diligence. And in that respect I have, I think, 5 tips. Tip 1 is due diligence. Screen your counterparties. Document what you have done in terms of screening. If you are screening one of your counterparties, make sure there's a standardized process of how to screen and that you have the availability of published sanctions lists. Tip 2 is once you have done the screening, at the same time determine how future transactions, if future transactions may require a license. It will save you a lot of time if you have this information up front, and it will minimize business interruption. Tip 3 is build in contractual protection. If you are in the process of negotiating a contract, make sure that you obtain certifications or warranties from your counterparty. At the same time, require your distributor or agent, if any, to perform screening. And I think that's very important, build in a contractual provision that allows termination or suspension of fulfillment of the contractual obligations if the sanctions apply. Tip 4 would be stay up to date with the sanctions developments. And tip number 5, my final tip, and I think a very important tip in this respect, is in case of any doubt, contact expert lawyers and ask for their advice. Byrne & Bird has a team of lawyers specializing in trade and sanctions regimes, keeping a close eye on all the developments in the sanctions, and are well placed to provide such advice.